Make it about the facts, not about you.
Well, glad to be back with you, Rob, here. We're talking about a four-part series that we're doing here about developing complete courtroom command. In this segment, what are we actually going to focus on, though?
We're focusing on how you analyze a case and how it's important to analyze it about the case, the facts and the witnesses, and not about your apprehension that you may have going to court.
Excellent. And now let's just give people a quick sort of the titles of what we're going to cover here so they can orient themselves. What are we going to cover here specifically?
We're going to cover the apprehension of going to court is actually your stuff and not the cases. It's about recognizing your past mistakes so you don't repeat them. And it's about figuring out the way you want to practice.
Excellent. Well, this sounds like good stuff, and hopefully it will get people fired up for that complete courtroom command that we want them to have. So let's take the list from the top here. So knowing that apprehension is your stuff. Are you blaming the victim here, Rob?
Never. But it's about recognizing that not every case has that same issue. You repeat the same thing. Oh, this case has this issue. This is why I can't take it to trial. This case has this issue. This is why I can't take it to trial. This case has this issue. We need to settle right away. After a while,
at some point, it's not the case. It's you,
yes,
right?
It's you. How are you
avoiding because you are feeling uncomfortable about being in that courtroom, right?
Exactly. And so it's about recognizing that, hey, it's your stuff. It's your apprehension. It's your fear. It's not about that. So when reviewing the case, look at the facts, look at the witnesses, see how people are testifying at depositions, see how things are coming through when you receive discovery, your admissions. Whatever you have in front of you, it's about looking at it from that mile-high view and not seeing it about you, but seeing it about the other parts of that case. So it's really about saying, hey, you know what? There's nothing I can do about my fear. It's not going to change the way I handle a case. Well, it shouldn't change the way I handle a case because the case is based on the facts and not about you, the attorney.
Right. So obviously, the better prepared you are on the facts, you're able to think on your feet comfortably because you really are thoroughly prepared, right? I mean, you thoroughly know what that's about, and you start to separate that from your emotional reaction or anticipation of the courtroom experience. So, if you're in your prep time, you're really prepping. You might also want to have some apprehension prep time about the whole courtroom experience, but they're two separate things, right?
Right, and I'm going to use a term that's normally an appellate term, but it's having command of the record as well. And there's no real record created in a lot of cases other than deposition testimony, but it's command of that record, so you know where all the evidence is, so you can turn to the page when a witness says something, you know exactly where that's located. Having that preparation done, having that command of that aspect of the case so you know it in and out, objectively, obviously, you're supporting your client, you're fighting for your client's rights, and you are confident in how you do it.
Right, because we've talked about this before, but I know that when people get really nervous, sometimes what they end up inadvertently doing in their preparation is they're kind of scripting in their mind how they're wanting the whole dialogue to go. And of course, that's a setup to really not be able to think on your feet, because the big problem is the other people in the courtroom don't know your script, right? You're just scripting it in your head. So by being deeply prepared on those facts, you can move in any direction, anywhere the script takes you, because you know what it's really about,
Yeah, I'll give an example of what not to do, and this is probably not a great thing to do, but here's what not to do. I knew somebody that